We're now going to move to Section 5, filing a complaint of discrimination.
Employees must file complaints of employment discrimination with the CHRO or the EEOC, even if they plan to take their case into court at some point. There's a requirement that you exhaust your administrative remedies, and the Commission on Human Rights and Opportunities is the administrative agency, the state agency that takes those complaints. We are also the agency where you must exhaust your administrative remedies if you're going to be filing a state action. If you're going to be filing an EEOC complaint as well as a state action, you can file with the EEOC and file an EEOC first complaint. After filing, the employee can request a release of jurisdiction or a right to sue to go to court. There are rules related to the filing of complaints in court when you receive a release of jurisdiction or when you receive a right to sue.
Now, where do you file? The CHRO has many conveniently located offices in order for employees to file their discrimination complaints. Discrimination complaints have to be filed within the geographic area of where the complaint occurred. If you visit the CHRO's website at www.ct.gov/CHRO, there is a town-by-town description under each regional office so that you will be able to decide which town you are in and which office you need to file in.
And sometimes people get confused. It's not where you live, it's where the incident occurred. So if you work in Bridgeport, then you would file your complaint in the Bridgeport office. You can live in Simsbury and work in Bridgeport, but you would still file in the Bridgeport office because that's where the incident occurred.
If you are unsure of where you should file, please contact the agency and we will direct you to the right location. It's also important to note that we have a separate housing unit. And if the case is a housing case, it needs to be filed directly with the housing unit and not in one of the 4 regional offices which are listed: Hartford, Bridgeport, Waterbury, and Norwich. Again, if you have any questions about where a complaint needs to be filed, please contact the CHRO and we will let you know which office the complaint needs to be filed in.
We have spent a considerable time talking about various protected classes in Connecticut, and we wanted to provide you with information regarding many of the protected classes under our law. In the state of Connecticut, there are actually 27 protected classes, and we're going to focus just on a few now. Age is a protected class because state law is different from federal law as it relates to age. In the state of Connecticut, you can be any age. If you're discriminated against based on your age, you can file a complaint with our agency. Under federal law, you have to be 40. So you see that there's a difference there.
Criminal record listed in these protected classes relates to state employment. The state of Connecticut is not allowed to discriminate against a potential applicant because of the criminal record. What the state employer has to do is a balancing test under 46A-80, where a balance is done between the actual criminal record, the felony conviction, and the job that the person is applying for. That's not true in private employment, but I caution you on this. Criminal record, while it's not protected under private employment, is something that the commission will accept as a complaint because it's a disparate impact based on race, color, and national origin. The EEOC has issued guidance related to how complaints should be accepted and processed as it relates to criminal record because of the higher numbers of race, color, and national origin complaints that are based on a denial of a job or dismissal from a job because of a criminal record. So it's important that as a company and as an employer that you're aware of what your policies are when it relates to hiring somebody with a criminal record in order to avoid a disparate impact complaint.
Also under the law, you'll find that there are several protected classes related to disability, learning disability, mental disability, physical disability. Why disability as a protected class is important for us to focus on here is the following. There are instances where an employer would have to accommodate an individual's disability to perform the essential functions of their job with or without an accommodation. And so having some understanding that disability is a protected class is very important.
We also want to discuss retaliation. Retaliation is its own protected class. And what that means is that an employee cannot be retaliated against for several things. The first is reporting discrimination. So if an employee reports discrimination to his or her supervisor, to the human resources department, and then are retaliated against, they are terminated, they are written up, they're given a lesser performance evaluation. If the terms and conditions of their employment are altered because of their complaint of discrimination, and also if they participate in any sort of proceeding, a court proceeding, a CHRO, EEOC proceeding, as a witness for somebody who's made a complaint of discrimination, any sort of negative behavior related to that by the employer would fall under the protected class of retaliation. There are many times when the behavior, the initial report may not be substantiated, but the retaliatory behavior by the employer is. That is as much a protected class as any of the other protected classes listed on this slide. So it's very important to make sure that no one is engaging in retaliation. It's also a best practice. You want to have an environment where people are free to report discrimination and are heard, and those cases are investigated without fear that there's going to be a negative consequence for that reporting.
Right. So even in the context of sexual harassment, if someone reports sexual harassment and then some adverse action occurs after they report the sexual harassment, that person may actually be being retaliated against for reporting the sexual harassment, which would then allow them to file a complaint of discrimination with our agency.
Correct. Sex discrimination, including pregnancy. This is a sexual harassment training, but it's important to note that Connecticut has one of the most robust pregnancy protections for women who are pregnant and who are returning to work after they have had their baby. Please review those sections of the statute. There are many changes to it that occurred 2 years ago, including reasonably accommodating a woman who needs an accommodation based on their pregnancy. One of the more significant changes that is coming with this statute is a change in the statute of limitations to file a complaint. Prior to October 1st of 2019, a complainant had 180 days to file an employment discrimination complaint with the Commission on Human Rights and Opportunities. For all discriminatory acts that happen on or after October 1, 2019, that filing deadline has increased to 300 days. And that is equal to what the EEOC's filing deadline is at the federal level. So it's important to note two things. One, the discriminatory act has to have occurred on or after October 1st, 2019 in order to qualify under the 300-day filing deadline. If the discriminatory act happened on September 28th of 2019, that act is still under the 180-day filing deadline. The second thing to note is that the 300-day extension of the filing date does not extend to complaints of housing discrimination or non-state agency public accommodation complaints. Their filing deadline with the agency remains at 180 days. Of course, there may be tolling and some exceptions, but it's important that as a general course, employees use the either 180 or 300 days, but very shortly the 300 days when they're calculating when they need to file their complaint of discrimination. Please pause the video and take quiz number 5 in the materials section.
Quiz number 5, question 1. What are some remedies a judge can award in a sexual harassment case? There are 4 options. Michelle?
Well, Cheryl, since we didn't talk about liquidated damages, I'm going to say the answer is D, A and B.
And you would be right. A and B. Back pay and emotional distress damages can both be awarded in a sexual harassment case. Question number 2. How long does an employee have to file a sexual harassment complaint at the CHRO? There are 4 choices. The correct answer is 300 days, assuming the event took place after October 1, 2019. It is important to note that the incident of alleged discrimination must have taken place on or after October 1st of 2019 to have a 300-day filing period.
Question number 3. Where does someone initially file an employment discrimination complaint? Cheryl, what are your thoughts on that?
I think it's D, CHRO or the EEOC.
I think you're right. It's important to note that what we discussed earlier is true. Administrative
exhaustion is required. You're right, Michelle.
That's what
you
I
must exhaust your administrative remedies and file with the Commission on Human Rights and Opportunities or the Equal Employment Opportunity Commission prior to filing in court, because you need a release of jurisdiction from the CHRO to file in court in an employment case, or a right to sue from the EEOC to file in federal court.
Question number 4. Which of the following is not a protected status in Connecticut?
Recreational marijuana, I would say.
I would say you're right. Well, it's important to note that Connecticut has legalized marijuana for medical purposes. Recreational marijuana is not legal in Connecticut and therefore is not a protected class. If you have questions about this presentation, questions about sexual harassment in general, or questions about changes to the sexual harassment statutes, there are many ways to contact the agency. If you would like to direct those questions via email, please send those questions to chroquestions@ct.gov. That email address is going to be monitored on a daily basis, and a staff member will get back to you regarding your question. If you prefer to leave a voicemail message, please call 860-541-3400 and press extension 7. That will lead you to a voicemail box that is also monitored on a daily basis. You can feel free to leave your questions there, and they will be answered by a staff member in a very prompt fashion. Lastly, we still will be offering in-person training by CHRO staff through the Business Training Institute. If you would like to request training on sexual harassment, housing law, employment law, or various other topics that the CHRO presents training on, please send those requests to chro.training@ct.gov, and you will be responded to in a prompt fashion.